Good morning, everyone. Welcome to today's session of Management of Judicial Stress. This session is very important considering the current times and considering that there's a lot of stress that is involved in while the judges are performing the judicial responsibilities. And I think there's the best part of this session is that Dr. Balram sir, who's the director for Chandigarh Judicial Academy, himself will be taking the session with his experience, with his being in the academy as well and being in the field for such a long time. I think it's going to make a lot of sense when he talks about it. And now today, I would like to welcome a lot of people because it's not only for Chandigarh Judicial Academy. We have people from various states, state judiciaries. So I welcome all of you on behalf of Chandigarh Judicial Academy and SCC Online. I also would like to welcome members who have joined us from the neighboring countries, Sri Lanka, Nepal, Kenya as well. So I would like to also welcome them. This session would be for an hour, wherein Sir would be detailing about everything, how we can manage the judicial stress, how we can overcome the judicial stress. And in case anyone has any question, so we will keep it for the last so that we can focus on what Sir is talking about and absorb as much as we can. And then in the last, there's a strip on your screen. You can see there's a question and answer option over there. You can click on that. You can type in your question, and we will address those questions in the later section of the webinar. So I think any further ado, I would request Balram Gupta sir, Dr. Balram Gupta sir. And first of all, thank him for taking out time. During this COVID period, sir, I think everyone has been concerned about. So sir is doing the session from his home, ensuring that the knowledge is being imparted, even if safety is a concern, but the knowledge is also important. So he's also taking care of that. So thank you so much for that, sir. And without any further ado, I would request you to please start the session, and we would love to hear you, sir. Sir.
Good morning. Thank you, Mr. Gill. The judicial co-personary. I have been thinking about the judicial stress. In fact, every human activity, every profession, every kind of work that one is engaged in, there are roughs and toughs. Integral to each activity, each profession for that matter. And therefore, the management of stress is very important. Stress is common to all professions for that matter. But each profession has its own peculiarities, its own specific challenges as such. And therefore, management, the art of being absolutely relaxed, performing your duties, is something which needs to be integral to every activity for that matter. When I was to go into teaching, way back 50 years in the year 1969, I was reminded of Edmund Burke. If you cannot do anything, teach. I thought that that's indeed an easy vocation that one can really think of. And in a lighter mood, somebody said, teaching is not a vocation, it's a vacation as such. The teachers remain on vacation most of the time. But I assure you, my own experience, teaching is a challenge, is a lifelong learning. what I gain from teaching, that is standing me in good stead in every other profession. But even a teacher faces such challenges if you're not communicative, if you're not articulate, if you're not comfortable with your subject, if you do not know the rules of the subject that you are teaching, it's a mental torture to be in class. The kind of stress. I have seen teachers at the university level, even in the months of December and January, when it is so cold, chilly months, coming out of the class, sweating. That's the kind of a challenge it offers. Medical profession, again, there is a challenge in that particular context. I had the opportunity of being in the operation theater with surgeons in action. When they open up, in spite of the PETs and CAT scans and other technological developments, they find something different. And that's the challenge that one, and the kind of stress. But I've seen the doctors managing even such difficult patients, aged patients, so easy. In the operation theater, they would be cracking jokes. They are serious about the performance of their surgical process, but yet they keep their mind absolutely relaxed so that they don't err on the wrong side in performing such real challenging situations. Same is true for the sports persons. The kind of competition that we face today in the domain of sports, you need real concentration. Martina Navratilova, the tennis ace, even at the age of 43, she could excel. She could win at the international level. She was asked, how do you manage? Even at this particular age, her answer was, the ball and the racket doesn't know my age. How I focus, how I really hit my strokes, that is what really matters. So it's the mindset that makes all the difference. And it is in this context, you know, having been in this particular domain for so many decades now, there have been many very effective speakers to speak on the management of stress, but they do not speak about the judicial stress. In general, stress, how do you manage? Yoga, meditation, good health. These are the basic recipes that they suggest. My focus today is on judicial stress because the kind of work that the judges are performing, that needs a particular kind of management. Judges are judicious minds, adjudicatory minds, independent minds, positive minds, productive minds, thinking minds. Neutrality is part of their personality. They prove that detached adjudication is humanly possible. They act fairly, objectively, equally. The strength of the judiciary is the trust and confidence of the people. That is the real beauty of the kind of work that the judges perform. This is a challenging task. And to play this particular kind of role, they must be free from stress. Otherwise, their work would be adversely affected. What constitutes, I ask myself, the basic structure of a judge in order to perform such daunting task that they have to do and perform? To do justice or to remove injustice, it is a responsibility, not a burden. And therefore, the first thing that I would say, that every judge must take it as a responsibility and not at all a burden. If you take it as a responsibility, what you need to do is enjoy your work that you're doing. Discharge your responsibility with utmost satisfaction. Satisfaction comes when actually you enjoy your work. That is what is the basic requirement. Judges decide disputes according to rule of law. The judgment of a judge must reason out as to why A has won and as to why B has lost. A clear articulation based upon the factual canvas and the law involved, the analysis, and come to a just decision in that performance of the entire responsibility. Judges never play the game of pleasing the parties. That is most important. In any judicial adjudicatory process, judges are not to please the parties. They have to deal with the situation which is before them. The moment they think of pleasing party A or party B, this causes stress in their minds. And therefore, it must be made absolutely clear. No reason and no justification to opt for pleasing the parties in that context. Number two, peace in the family of a judge. Peace of mind. You know, this is what is the requirement. If you have good, happy family life, you would be able to perform in court and outside court much better. No stress, the family stress. I'm emphasizing this for a particular reason. And the reason being that unless a judge enjoys good, healthy family life and peaceful life, he or she will not be able to concentrate on his or her judicial work. And that is what is basically required in that context. There should be no pressure. There should be no request from anybody to do a favor. And in this particular context, the parents, the elders, particularly of the young judicial officers, need to play a very positive role. What is that positive role that they are required to play? Sometimes the father may think a very close friend, the case is before my daughter or before my son, I could ask her to take care of the same. There have been such situations. You know, this kind of thing gives stress to a young judicial officer and even to a senior one. The dilemma to say no to a father and at the same time not to accept what the father wants him or her to accept. And therefore, in that context, there is need for family coordination, cooperation, particularly of the judges in the performance of their judicial functions. No interference at all in that context. Judges, to be free from stress, must be positive minds. Suspicious minds do not make good judges. My experience at the bar, a suspicious mind, a judge, smells the rat in every aspect. That is negativity of mind. Judges must kill negativity. They must think positive, act positive, do positive. Then alone they would be absolutely free from stress in the performance of their judicial functions. In that context, many a time I'm asked, what is the role which the Judicial Academy is required to play? And my response to that is, judicial academies play the role where the young judges from the classrooms go to the courtrooms. And in this transitory process, what needs to be done is cultivate happiness, happiness of mind. If the judicial academies are able to concentrate on this particular aspect, it would be nurturing the young minds so effectively, which would go a long way in the entire process of their judicial career. And therefore, what I am urging today, that the academies must nurture the young judicial minds with happiness, cultivate their young minds as to how to be happy in performing their challenging task of adjudicatory functions. This is very, very important. Happiness is inbuilt. A smiling face makes all the difference in the court, outside the court. and in the performance of the judicial functions in that context. Having laid down the basic structure of the judges, let me take into some of the challenging fields which a judge has to manage in order to be free from stress. The relationship between the bar and the bench is most important. The coordination between the two is significant. The friction between the two causes stress in the minds of the judges, in the minds of the lawyers too. And therefore, the management in this particular context is absolutely important. What is the true role of a lawyer? A lawyer is an officer of the court. We all recognize that. Consequently, the lawyer needs to be treated like an officer. But equally, the lawyer also owes an obligation, a responsibility to the court, to the judge, to the bench. For instance, if the lawyers coordinate, the delays in the disposal of cases to a large extent can be minimized. In the sense, not to seek adjournments. The judges are faced with this kind of a situation, that frequent adjournments are sought. And therefore, in that context, the judge has to work out uniformly to treat every lawyer in the court equally. If there is a cause for an adjournment, yes, it needs to be in the interest of justice, adjourn the matter. But certainly a judge can monitor why repeatedly, and that may not be allowed for that matter. Secondly, anyone who engages the lawyer pays the fee. The duty of that lawyer is to fight for his client and do his or her best to win the case for the client. But the journey doesn't stop here. It is not one-way traffic. It's not winning the case for your client. What is the true role of a lawyer and what is the role of a judge? And that is to ensure truth prevails, to ensure that justice is done. And therefore, for instance, as a lawyer arguing on behalf of his client, knows that there is a particular judgment which does not support him. Now, either he distinguishes that judgment and helps the judge in distinguishing that particular judgment so that the viewpoint of his client could be taken into consideration. Or even if the opposite counsel does not know about that particular judgment, that doesn't mean that the lawyer is not to share that judgment with the judge, with the bench as such, in the open court. Share it, deal with it, Distinguish it if you can, because ultimately the effort of the legal and the judicial corpusculary together is to do justice. Truth must triumph. That is the effort that is required to be put in. Because if this is so, there would be no stress on the mind of the judge. The judge knows that a fair game is being played by the lawyers. Everything is being brought to the notice of the bench. And in writing the judgment, the judge would be so comfortable knowing both the sides, reaching the conclusion in that context. Let me share with you an actual happening to bring across my point of view. K.L. Mishra, Kanhaiyalal Mishra, was the Advocate General of Allahabad High Court. He was to appear in a matter opposing the petition of Ram Manohar Lohia, the socialist leader of the yesterday years. Mr. Lohia was to appear in person. He was not a man of law. Mr. Mishra went to the jail where he was detained and briefed him about his own case with judgments. Having done that, Mishra's explanation was called that how could you do this, that you go to the opposite party and help him in regard to the entire matter? You are fighting for the state. And therefore, his explanation was called. You know what was the response of the Advocate General? That my duty is to ensure justice is done in court. And if I have told Mr. Lohia what is the law and what judgment supports him, I'm only making an effort equal to bring to the notice of the Honorable Court as to what is the rule of law. My job is not to win the case. My job is to ensure that justice is done. Now, if this is the role of the bar, if it could be understood, think that the stress on the mind of the judges, would there be stress? The judges would be so comfortable knowing well both the sides would be presented. And the judge is the adjudicator, the final adjudicator to decide that particular matter. And therefore, there would be no stress on the minds of the judges. If this could be actually carried out at the level of the lawyers, that would be a real actual contribution and coordination on the part of the bar and the bench. This is what is expected. Judges also need to treat the bar with equal hands. No favorites, no favors. Absolutely to treat them only to assist the court to arrive at the truth of the matter so that justice can be done in that particular context. You know, this I'm saying because it would help ultimately the judges in writing their judgments. If the judge always feels that entire thing has not been brought to my notice. I have to work of my own. And I have to dig out, find out the cases, this side or that side. The work of the judge goes up, and his peace of mind and absolute freedom from that would be disturbed, which is most important in writing their judgments. One of the aspects which normally is the cause of concern, the judges are required, particularly at the district level, to give units quarterly. My basic response to this particular, because this is something which is a matter of concern for one and all. One must manage every aspect, every case in an effective manner. And therefore, the best recipe which I can think of and which would de-stress the judges, once you complete the matter, you've heard the arguments, don't delay your judgment. Judgments must not be kept pending. Keeping the judgments pending is a cause for stress for the judges. I know certain things are managed, and many a time the different dates are given because the judgment is still not ready to be pronounced. The best thing is, at the earliest possible, the judgment must be dictated. I would be told, and my own experience as a lawyer, a client comes to me, I hear his story, keep the papers, and I think I would dictate the petition in a couple of days. If I don't do it in a couple of days, the petition remains pending for months and sometimes even far more. And therefore, my own experience is never keep your work pending. There are judges who excel in dictating the judgments in the open court. That's an art which experience teaches you. M.C. Chagla, during his long judicial career, only in 2 cases he reserved the judgments. Otherwise, heard the arguments, dictated the judgment in the open court itself. And even in those 2 cases, only because of the fact that he wanted that the other judge should agree and we should not be giving 2 separate judgments in a particular matter, for that matter, to bring uniformity. That was the basic concern. Let me share with you, there have been situations where even at the High Court level, cases are heard, judgment is reserved. Even after a couple of years, the judgment is not pronounced. This has happened as such. A writ of mandamus was filed seeking a direction against the High Court judge to pronounce the judgment of a case which was heard more than 2 years back. Embarrassing situation. There have been situations where dozens of judgments remain pending. Those are exceptional situations, but They are the real cause of judicial stress. I would urge that if you wish to be free from that kind of a stress, make sure that you pronounce the judgments on time. That keeps you relaxed. If you have pending judgments, that itself causes stress on your mind. You must be free from that. Magna Carta of the year 1215 projected three things: not to sell justice, not to delay justice, not to deny justice. If the case has been heard, already there has been time consumed, months and sometimes years. And after the arguments have been heard, if the judgment is not pronounced for months or for years, will that not be a matter of concern? In fact, I know for certain, if the judgment is not pronounced, all kinds of whispers are heard that there must be something which an extraneous consideration because of which the judgment is not being pronounced. I would urge the judicial fraternity, make your best effort to pronounce judgments on time. That's the best way to keep your mind relaxed and not to have it stressed in that context. Sometimes very challenging situations come before judges. I would like to share particularly that matter of 2017, the Sacha Sauda Baba Rahim's matter. What a serious situation when the judgment was to be pronounced by the CBI judge, Mr. Jagdeep Singh, for that matter. Lakhs of people all assembled in Panchkula. Situation was tense. Even the army was called. Anything could happen. And you know, so many lives and so much of property was lost in that particular situation. I was wondering what must be going in the mind of the CBI judge when he was to pronounce the judgment. So much of scare, threat, the security, the safety of the family, of the children. Anything could happen. The judgment was pronounced on the 25th of August, I still remember, of the year 2017. I talked to the district judge and I said I wish to come and meet the CBI judge and the entire district judicial family. I went over, talked to Jagdeep Singh, asked him what was going in your mind at that particular time when you were to pronounce the judgment. He shared the only concern was, before anything happens, I must pronounce the judgment. That was the serious concern which he demonstrated. And the manner in which he acted I complimented. And I said, you are a reflection, and you have been able to create the trust and confidence of the people in the district judiciary in the manner in which you have acted. I can imagine the kind of stress that must have been on his mind in that kind of a situation. And therefore, in that context, his handling the entire matter was something which was so meaningfully handled and carried out. That is the kind of a challenge that you have to meet, but you can meet it only if you are strong and not be under that stressful situation. You are able to do justice and stand for the institution to which you belong. Another cause of concern, you pronounce the judgment. And after pronouncing the judgment, there is an appellate jurisdiction, there is revisional jurisdiction. I've talked to many judges. They often say there is always a concern. My judgment may not be overruled, may not be set aside on appeal. That should not be your cause of concern. There is yet to a judge to be born who has never committed a wrong, it's a wrong judgment for that matter. The trial court judgment on appeal, some are upheld, some are not. And you go on second appeal, the same story is repeated. May it be the High Court judgment to before the Supreme Court judgment. And therefore, this should never stress your mind at all. What needs to be taken care is that you decide with due application of mind in accordance with rule of law. And beyond that, you just forget about it. If there is some extraneous consideration which is palpably manifest on the face of the judgment as such, it is in that situation that you are inviting trouble. And in that situation alone that you need to take care of such a situation should never arise. Why am I saying this? Your duty is to decide according to rule of law. The moment you waver in that, it's going to cause you concern. It is going to cause stress in your mind. And you must make sure that this does not happen at all. This is something which must be avoided under all circumstances. This is most important. You know, how do you keep yourself free from that stress? That is what is the real test of a judge. That your effort is to arrive at the truth and to do justice to the parties. And if that you are able to do it, let me share with you, way back in the year 1905, Badruddin Tyabji was a judge of the Bombay High Court. Two of his sons were practicing in the same High Court, Bombay High Court. And invariably, the two sons would be engaged by the two different parties, one and the other party. Now, Badruddin Tyabji was known for doing justice, which means the case is decided on merits, but the counsel in both the cases happened to be the two sons. He was not concerned which one wins and which one loses. Now, I view this particular situation. In fact, the matter went to the Chief Justice. And when it came to the notice of the then Chief Justice, Jenkins, a concern was shown by the Chief Justice. Badruddin Tyabji responded by saying, "Mind your own business." That was the kind of a strength that he was having. That I'm doing justice, I'm not playing with justice. My own response to a situation of this kind is, yes, he must have been doing justice, but justice is not only to be done, it must manifestly appear to be done. And therefore, if in the present context we deal with a situation of this kind, I would urge such a situation should never arise. This is not a healthy practice, and I'm sure this would be a stressful exercise on the part of any judge. Should never be done. Your judicial conscience is your best mentor, is the best projector through which you have to see, and it should not be really reflected in that context. I would like to share Justice H.R. Khanna's. He was to be the Chief Justice of India. He was to deliver the judgment in the matter of ADM Jabalpur in the year 1976. It was a bench of 5 judges. He was differing from the view which was being taken by the 4 other judges. He wrote a dissenting judgment, and before pronouncing, he shared it with his sister and said that I have prepared a dissenting judgment, but it would cost me Chief Justiceship of India. Now, it was a situation. The sister said, doesn't matter, do what your judicial conscience permits you. Don't have a stress on your mind on that score. He pronounced that dissenting judgment. It did cost him the Chief Justiceship of India. He never came to sit in court number 1 in the summit court of the country. But the kind of respect that he earned around the globe, even if he would have been the Chief Justice of India, he would not have got that. This is this judicial conscience, which is the best monitoring factor which every judge must keep in mind. This is something which really is something which needs to be carried forward in that context. There have been many other situations where persons, the judges at the highest level, the Chief Justice of India, I would like to share what happened way back in the year 1968 in the Supreme Court. It was a bench of Chief Justice M. Hidayatullah, along with Justice Ian Grover and another judge. The case was heard. The judgment was being dictated in the open court. One of the persons jumps up to the table with a knife in hand to attack the bench, the judges. Justice Ian Grover got 2 knife cuts on his neck. Justice Hidayatullah held the hand of that person. Now, Justice Hidayatullah took Justice Grover in his own car to the hospital immediately, drove the car himself, jumped the traffic lights in order to reach the hospital without wasting the time. And in that particular context, he saved a human life. It is in that context I say, look at the presence of mind that he himself drove the car in spite of the fact the attack was on him also. He saved himself and saved another judge. This is where your firmness as to how you to deal with a situation of this kind. I'm conscious of the fact such situation or situations have arisen at the district court level also. Either the lawyer or some other person, the litigant, hits the judge. Now that's the kind of a situation now a judge has to face. This is peculiar to the judicial officers, the judges. And therefore, this should not deter the judges from performing their duties with a free, relaxed, open, objective mind. You know, this is what I'm saying, that there are so many stressful situations which a judge has to face during his or her lifetime. And it is in that context that if this particular aspect could be taken care as to how you manage the stress, let me assure the entire judicial fraternity in India, beyond India, these challenges come. Stressful situations are there. Indeed, there is no doubt about that. But how you keep your mind cool, how be not to be aggressive in court, how to have a balanced mind. Let me share with you one story. In London Times, long time back, a news story appeared on the front page. The caption was, "Old Fools," with photographs of 3 members of the House of Lords. Well, that story appeared. No contempt of court notice was issued. Everything was taken care as such. One of that member of the House of Lords happened to come to India after some time. Just Fali Nariman, such a well-known advocate, jurist that the country has produced, happened to meet him and specifically asked that this story appeared with the caption, "Old Fools," and yet you did not issue any contempt notice. You know what was the response? He says, old is a matter of fact. Fool is a matter of opinion. What was there to issue the contempt notice about? See, look at the free mind, the balanced mind a judge must have. Don't take anything such personal. Many situations arise where judges are personally into a particular given situation. Be broad-minded. Be happy minds. These small tinkers do not matter. A judge is known by the contribution through the judgments that he or she makes. And these small episodes should not really matter at all. I'm very fond of sharing a story, what happened in Lord Danning's court, which I think is a real judicial stress buster for that matter. On Mondays, Lord Danning used to hear the cases of those persons who wanted to present their own case, argue their own case in person. On a particular Monday, a lady appeared. She argued the matter. Finally, the petition was dismissed. The lady got furious. There were books lying in front. She picked up a book and threw at Lord Danning. He ducked, and before he could realize what had happened, the second book came flying across to him, and the third one. There were only 3 books, fortunately. Lord Danning didn't say a word to her. Didn't ask the orderly, don't let her go out. Contempt notices to be issued, nothing. He was cool. She goes to the exit door, stops there, and says, how cool, even in a war situation, and she walks out. After she goes out, Danning says, it was a matter of sudden provocation. Look at this kind of coolness, that it doesn't mean that he's condoning what, but it shows how he manages and handles situations which arise. It is in that particular context that I wanted to share some of these episodes. This particular issue of judicial stress is something which concerns every judge. I may not have been able to give it a wholesome treatment, but my effort has been just to focus. Be positive. Be happy minds. Be broad-minded. Enjoy your work. Have the satisfaction of doing justice, which is divine. Your journey would be contributory. You would be remembered for the contribution that you make, at whatever level you may be. But make sure Don't make your journey stressful. Think how best you can. Help yourself out. These are some of the tips that you need to keep in mind. A healthy mind, a happy mind, a contributory mind. That is the best which a judge can do and contribute. Thank you so much. I'll be too happy to respond to the question. I know I may not have been able to do justice, but I'll be very happy to respond to the questions. That's that.
No, I think, sir, yeah, it's not about being justice. I think you have told a lot of things. I think I've already got a compliment for you, that which I would like to share with you. Neeraj Goyal, sir, who's a very active member in all the webinars. I'm pretty used to seeing his name. He has passed his regards. He has said that this is not a question about compliment, sir. The best message conveyed, taught today, is to enjoy your work with a sense of responsibility and not to take it as a burden. This is the best way of doing your work effectively and without any stress. This message reminds everyone the way we are doing his work is without any stress. So I think people resonate with you.
Thank you so much. I mean, I feel so good that
Yeah.
this has been taken in that spirit.
Absolutely, sir. I think I think it's very the learnings that you have shared today. It's to the point, and the best part is the examples that you have shared with all the stalwarts of a fraternity. And when they don't react to a situation that you've given example of, like the newspaper headings calling someone an old fool, and then talking about Lord Derring's, what happened in the courtroom, the lady threw books and all. I think that's what make them, what they are, what they were, and that's why we look up to them. Still, we, refer to them in every speeches of ours. So I think it was marvelous. Oh, there's a compliment again. Dr. Rajneesh has said it was a marvelous session. So I think there's so many learnings. I was writing down, so I couldn't get a piece of paper, so I was writing on an envelope, and I have written on so many things. But I think all the judges who have attended the session, and I'm so glad. I think, sir, I'm thankful to you that you agreed to open the session up for all the officers, not only from India but also from other countries. I think this session, personally, I had like a very good time on this one. So,
How many have been able to join this particular
so
session?
they were approximately 400 at one point of time, but the 400, the actual number, I will get the report, and I think the number would be almost double of it. There is one question as such, sir, on this. Because you were talking initially, we were talking about that the judicial officers should take care of things and should not be stressful about things. They should take the decision as soon, they should pronounce their judgment as soon as possible, and they have to be live in present. They don't have to think about the future, that the judgment gets overruled or set aside. But there is another question, which is not about which things which are not in their control. The question is about that what is required to be done with the judges having marital dispute pending. So I'm assuming that the question is about their marital dispute being pending.
Right. See, let me respond to that.
So,
A judge, it is understandable, can be into a personal litigation as well. After all, judges are human beings. I'm reminded of Harold Lasky. He wrote a letter to Justice Holmes of the US Supreme Court. And he said, how much I wish if people could understand that judges are human beings. Justice Holmes wrote back to say, how much I wish if judges could realize that they are human beings. It is this realization. Every human being at some time or the other would be involved into something as such.
yes.
But in spite of that involvement, when you're performing your judicial functions, you have to manage yourself. You have to do things in a manner which would not disturb your mind because of your personal problems. I know it is so difficult to detach yourself.
Yes.
You know, detached adjudication, it is often said, is not humanly possible. A judge wears bifocals and has to see so many things. But at the same time, it's your training your mind, tuning your mind, and yet keeping the equilibrium of your mind. It is difficult to actually do so. It is easy to say so, yet everything is possible. For a judge, it is not impossible, and therefore it has to be managed in that manner.
Sir, certainly, sir. I've been getting a lot of compliments for this session, but I think I will read these compliments at the last. I will refer to one more question.
More questions, as many questions.
Yeah.
I'll be very happy to respond because it's the questions which brings out the best.
Exactly. So that's why I'm keeping all the compliments. I'm sorry to all the members. I will read out all your compliments to Balram sir. I will read it out, everyone's name and everything. But I think I'll just focus on the question first. So there's one other question that says, as judges, what should be kept in mind while sentencing an offender?
Yes, that's a very interesting question. Sentencing itself is a fair game that has to be exercised by a judge. What has to be kept in mind? The factors aggravating and minimizing a particular situation. You have to balance the two factors together. It's like a balance sheet. The credit, the debit, and bring out the result out of that. In the US, they have provided fixed terms under different situations, particular situations as such. To mine, it is a computerized kind of justice or sentencing as such, which is not fair. It's the human mind that plays its effective role in determining the sentence. What human mind can weigh, consider, and come to a conclusion, computer cannot, or fixed rules cannot help you with that. Each situation is a different situation. Each issue is a new challenge as such. Each mind is different from the other. And therefore, in determining the sentence, you have to have a balance sheet before you and see, for instance, the age of the offender. The other circumstances which were contributory in a given situation. Look into every aspect and then come out with a balancing sheet, an order which would determine that. That's how I would. There can't be a straitjacket formula for this particular aspect.
It is. There's one very important question, I think, which you also talked about, that judges are also human beings and they sometimes get into the self-doubt. Now, the question is about on the same line that, how do I control my inner thoughts, which keeps me questioning me whether I'm able to serve well or not. So it's a pure situation of self-doubt. The person wants to do it, but then the self-doubt sometimes, takes the have a higher weightage on it.
I'm so very happy that this question has been asked. It's a dilemma which judicial minds often experience. I've never been a judge, and therefore I would be accused that you have no locus to talk about it. But, I am a consumer of the judges, what they perform and do as such. And as a consumer, I'm speaking today. I often tell the lawyers, you must understand and know the judge. Knowing the judge doesn't mean that you have your friendly relations. Knowing the mind of the judge. When you have to argue a case, each judge likes certain things, dislikes certain things. You should be able to, with experience, penetrate in the mind of the judge. Now here the question is, it's the dilemma for a judge, am I doing the right thing or not doing the right thing? Think over it, do application of your mind, and what your conscience permits you, do it. And once you've done it, forget it. Let it not disturb your mind any further. Yes. Your conscience is clear that you have done what you thought to be the best. And thereafter, I always advise, please do not ponder it. Don't have sleepless nights. Just forget and think that you have done your very best. Even if the appellate court doesn't agree with you, doesn't matter. Two opinions are possible. It should not at all be a disturbing factor for a judge. That's what my candid advice in this regard is.
Certainly, sir, certainly. I think, let's see if we have any question. One of the best examples is so I think the example that you gave of ADM Jabalpur case of Justice Khanna, I personally know that judgment as well, because the very interesting part of that judgment, sir, in the ADM Jabalpur, like you mentioned, there was a dissenting opinion of Justice Khanna, and that's what Neeraj Goyal sir is also saying from Khanna district, saying that it's a very good example. In case Puttaswamy case, the majority opinion was overruled, and Justice Khanna opinion, which was a minority view, was upheld. Exactly. So it is not, like you said, it is not about going with everyone.
See, let me put it this way.
Sure.
In that ADM Jabalpur 1976, the senior Chandrachud, Chief Justice Chandrachud, was with the majority.
Yeah.
And now in Puttaswamy's case, it is his son, the younger Chandrachud, Dhananjay Chandrachud, who has overruled this particular judgment as such.
I know.
And I mean, it was a predicament for him to overrule his own father. Good that you brought in this. Yeah. See, this also, I mean, it must have been sometime. I mean, he has shared this.
Yeah.
It was a stressful thing.
It has to be, yeah.
Well, it was a stressful thing, but he applied his mind, coolly thought, if I would not do it, who else would do it?
Yeah.
And that's how he met the challenge. This is the best possible example that one can really think of in this context.
I know, sir. But like I think this actually was a very good example to And now because we have completed the entire string of it, like how it's got overruled and who overruled it, I think that makes it a full circle and showing that you have to take some decisions which are, and I think senior Chandigarh sir was, anyways, he was stalwart, and everyone looks up to him, and doing something to his judgment, and that to his own son, I'm sure it would be really, really stressful for himself as well. I think that's what.
See, that's the beauty of our judicial mind. That's the real beauty of the judicial mind. And we want more of such examples.
I'm sure, sir. I think I've been getting a lot of compliments in the question. I think I'm getting less questions, but more compliments.
I want more questions. I want more questions.
I have one question. I think it is very. I think this has not been done till now, but I think it's a very good suggestion and a thought rather for now. The statement goes like this, that as there has been a acceptance of the fact that there are a lot of stressful judges in India for various reasons, sir. Don't you think there should be a research on those reasons and then there should be solution? Leave aside yoga and meditation because these days judiciary is on attack by every strata of society, and the media trials also. There is bona fide mistakes also the fact there are these experienced judges who are less because recruitment of very, very young officers are coming up, and it's a lot of things are going on. So what we're saying is that we always suggest that do meditation, do yoga, but what the officer is saying, that don't you think there should be more constructive efforts, something substantial should be done?
Please. You know, why I have thought of taking this particular session on judicial stress. In my own domain, I had been trying to have sessions for the judges how to deal with judicial stress. And each time, renowned speakers whom I called, they would deal with yoga, they would deal with meditation, but not focusing on actually the situations which cause the stress to judges and how to deal with them. That was the reason I took it upon myself that I must share my thoughts in this regard. It's a very good suggestion. You know, judges, as I said, are after all human beings. They are prone to human failings also. After all, every human being does something wrong at some time or the other.
Yeah.
And in that particular context, a judge needs to be trained and tuned as to how to keep away from those situations. And therefore, the conduct of a judge, the behavior of a judge is very important. Focusing on building up the personality of a judge right from the beginning. And, certain things totally a taboo for a judge. Consequently, if still certain judges do indulge in certain situations, act in a particular manner, I'm sure a serious researcher could take up the research, take up different cases of judges. It's high time that we could come out with and unfold what led to this or that situation. Why did this happen? Every judge knows judge has to be independent, judge has to be honest. To say he's an honest judge is no qualification. If you are not honest, you are not qualified to be a judge.
I know exactly. That's a minimum. And that's a that's a minimum benchmark.
And therefore, in that particular context, if something goes wrong, must have been certain compelling circumstances. And if a study could be carried out, under what circumstances, who did what, and how, if such a survey could be done and study could be done, I think it would be contributory, exactly. It would be meaningful, it would be useful for the judicial fraternity as such. And, one must know, I am not perfect. Nobody is perfect. I must be suffering from certain negative aspects as such. It's the others who can judge me. And therefore, to be open to such. Let me tell you, there have been certain judges who had been my students. Before accepting the judgeship, even at the High Court level, they would talk to me, will I be able to live up to this particular responsibility which is being given to me? That's the kind of a feeling with which you have to accept your challenge and live up to it. Good that such a kind of a study should be conducted.
So, I think, sir, it's also a factor. I think while you were talking, I was thinking that I think mental stress is in regards to its respect to mental health as well.
You said it. Mental health is very important.
So,
it's the healthy minds who contribute hugely, live longer. I can give you examples. Fali Nariman is 90 plus. In this part of the country, in Chandigarh, we had Hiralal Sibal, the senior advocate, the father of Kapil Sibal. He was 99 plus when he expired. Justice Holmes, Oliver Holmes, 94 that he lived. Khushwant Singh, close to 90, 100 for that, but 99 plus. Justice Krishna Iyer was 99 plus. Lord Denning was 100 and plus. So mentally to be healthy.
Yes.
You live longer, you contribute hugely.
Yeah.
And that is the recipe of a good judge, for that matter.
So,
have a healthy mind, wear a healthy mind, and I'm sure you will contribute hugely.
Absolutely, sir. And I think the question that you were answering prior to this conversation about the research should be taken care of. I think earlier we never used to think about physical fitness or physical health. Now the days have changed, and now lately everyone has started talking about that mental health is also important. So I think what the judges are talking about, what the officers are saying about that there should be a research done. I think we are working on those lines because at least we are accepting that mental health is also need to be addressed.
Absolutely. See, the young judicial officers who come to the Chandigarh Judicial Academy, and I go across at the National Judicial Academy also, I had the experience. I always tell them, read the autobiographies and biographies of the best of lawyers and judges. They are a storehouse of life experiences as such. That's a learning, and each judge must carry it out. You learn so much, and it motivates you. It nourishes you to do certain things which have been done with the best of minds in the past years. That is the beauty of a judicial mind.
Yeah. So let me go to the next question. I think a very common question, and I think one person, Arun Gupta sir, has asked this question, but I think this will address all of us sitting on this webinar. The question is, a lot of times when in the ongoing case, the case becomes a media trial case, and the media keeps coming up with new things. So the question is that should we, as a judge, should we stop watching the TVs? Should we stop reading newspapers and detach ourselves completely from media while the case is going on?
That's a very pertinent question, and I'm happy. See, what you hear, it does impact your mind. Judges are no exceptions to that. And therefore, it is desirable that judges should not be subjecting themselves to the TV, media, or any other particular medium, because it does influence your mind. Media is projecting a particular angle with a particular object, whereas that may not be the right way to look at the situation. I would urge, see, it is difficult to completely detach yourself. I mean, reading a newspaper, I used to tell my law students also, is as important as brushing your teeth every morning. I used to say that. And I wouldn't tell my judges not to read the newspaper when a trial is being carried out.
Yeah.
Do read it, but keep your mind open. You have the different projections, and let the material come before you. Be not swayed by this side or that side as such. That is the beauty of a judicial mind. That is what actually is required of a judicial mind. That is how it needs to be done.
I think members are agreeing with you, sir. Well, I think you gave a very good suggestion that that they should read the newspapers and all, because that's that you need to know what is happening. Also, members are also agreeing with you that learning from their own mistakes will take a lot of time. So reading biographies means learning from other people's mistakes.
Absolutely.
So members are actually agreeing with you on that. I think it's right. I think in today's world, I think if you don't have time to commit your own mistakes and then learn from them, it's better there people have committed same mistakes in the past. Read the biography. I think that's what I think you said. Moving to the next question, sir. It was about okay. It was about the lawyers, sir, the young lawyers. It says that no doubt the lawyers are the office of the court, and he will be given respect by the court. But nowadays, some lawyers are not feeling responsibility towards the court, and they do not respect the court. Do you think it's a high time to conduct classes for young lawyers, like by you?
Say yes, why not? I'm conscious of the fact that lawyers do not conduct themselves at times in the manner in which they are required to do. I belong to their fraternity. I've been a part of that fraternity, initially as an academic lawyer and later as a professional lawyer. Yes, they need to be also tuned and trained, act like the officers of the court. That is what exactly I was emphasizing when I was referring to K.L. Mishra's case relating to the role of a lawyer. The role of a lawyer is not to merely win the case, bring the true picture, the rule of law before the court, and let the court decide about it. You have done your duty. There's no doubt about it. It needs to be done. The lawyers need to be told and trained in this particular, that how to be the officers of the court, how they have to play their role. They need to be contributory to the justice delivery system. And that is possible if this suggestion is taken into consideration. They should also be. And this duty can be discharged more effectively by the bar councils of the different states. As such, they should undertake this particular responsibility. There is absolutely no doubt about it. They need to be educated in this context.
Yes. So I think you're right, sir. At the starting level, it should be addressed rather than waiting for them to just come and then something can be done. I think if the bar council can do it at the start of it, I think this should be set some like set of norms that they should go through. That okay, these are the things that they're expected out of them, not only just fighting a case.
Absolutely.
Now, sir, this is a very interesting question. It's a one-liner, but it makes a lot of sense. It says, "Is it true to say once a judge is always a judge?"
Yes, I would agree with that. You know why? Let us say A has been a judge at the district level, then at the High Court level. Retires. After retirement, yes, you do engage yourself in different activities. You play a different role as such. But whatever activity you are involved in, can you be divorced from your background as a judge? Can that be taken away at all in that particular context? See, it has become a part of you. When I joined the university, I was told, once a teacher, always a teacher. And that's true. There's no doubt about that. Similarly, once a judge, remains a judge always. It means, it indicates what? Whenever something happens, we ask a retired judge to conduct the inquiry, the probe. Why? Because the judge in him has not gone out. He would judge it judiciously. And therefore, is truly said, once a judge, always a judge.
So, I think it's with all the professions, sir.
It is true of all the professions. Yes, I agree with you.
Like you said about the teachers, like you said, it's not a vacay. It's a vacation. A lot of people say, but like you've been teaching, and I think even now, you say that okay, let me share information. So I think once you have expertise, once you have spent so many years, you want to share, you want to give back to society all the time.
Let me share with you.
Sure.
I was at the bar as a senior advocate, designated senior advocate. When in the year 2013, I was asked to take charge of the National Judicial Academy. My Chief Justice in the High Court here in Chandigarh was Justice A.K. Sikri.
Okay.
I went and met him. He knew that I had been offered that, and he was, in fact, played a role in that particular context. I said, my son tells me, Papa, these are your harvesting years in the profession, and you are running away from the profession. Justice Sikri smiled and said, Balram, this is the time when you have to give back to the society. This is exactly what you were saying.
Sir.
And truly, And number two, what he said was why I had been picked up for this irresponsible position. He said, you have grown in that environment which is needed for a National Judicial Academy. And therefore, you know, even when I came back and now looking after the Chandigarh Judicial Academy, I enjoy being with the young judges.
I can tell, sir. we keep on talking like morning, evening, all the time. So I can tell.
So that's the beauty. I mean, that is what sustains me into it. If I can contribute, if I can share something, my experiences, that's my joy of life.
Sir. I think I have one more question, and then I will read out few of the compliments of everyone. So the question is during that so during the COVID-19 period, there's a lot of stress of work which has been put upon judges because staff members and judges are being infected almost on a daily basis. And in some districts, subordinate judges are being, pressurized to perform by coming to the court, giving units, and holding training sessions, etc. So, how can you manage stress during these times?
Yes, these are extraordinary times. In fact, the very first session that I had taken was in the context of COVID-19.
Yes.
See, the effort is to have virtual courts and not physical courts, to my mind. Maybe at the Supreme Court or the High Court or the District Court. Could be possible to an extent as such. Understandable. In spite of this, yes, some of us, including the judges, the young judges also, have been victims of this coronavirus as such. This is a hazard of the profession. I'm sure certain things can be done, and I would look into it if something of this kind has happened or is happening as such. At my own level, I would share this concern at the High Court level also. I understand this particular difficulty for that matter, but take all precautions and do your very best to keep yourself away from this particular situation that we are faced with. And if it so happens that you become a victim of it, in the sense, do your best to come out of it also. Keep your mind positive. I'm sure most of us would come out of it. I wish and offer my blessing that nothing should happen to anyone for that matter. I feel concerned about it. It's the human lives that we are, but yes, that's what the situation is.
Right, sir. Yeah. But I think, sir, I think you would agree with me on this because we have spoken about this earlier in the past as well, that like Chandigarh Judicial Academy, the main work that Academy has been doing is to train people and to share knowledge. During this COVID period, we came up with this alternative of doing webinars.
That's right.
And similarly, there are e-courts being put in place. So I'm sure, I think members, there might be some places which are not that advanced. I'm not really sure if this question is from Punjab, Haryana, or some other state. There are few subdivisions, there are few talukats which are really remotely located, and members probably don't know about these features of webinars and Teams and other softwares. So I think my 2 cents of advice would be that reach out to your specific academies. They might have some suggestion or some solution that how you can come up with this challenges.
I mean, of course, Chandigarh Judicial Academy would take the lead in this particular regard, and I would address this issue.
Sure.
Delhi University, Delhi Judicial Academy could also be another partner
Yes.
in this. And the Madhya Pradesh Judicial Academy also.
Yes.
We have the present Chief Justice here who was the judge and looking after the Madhya Pradesh Judicial Academy. I'm sure we are already interacting as to how to do the things here.
Yes, sir.
We would definitely do our very best in this particular context.
Absolutely, sir. Sir, now this question is, I think I had this question myself, but I didn't want to ask this question because I was not really sure if it's only my, it's a question in my mind or is it actually a question. From the time the new changes have been done that, after your graduation, you can become a magistrate, you can become a judge, and you don't have to serve for 3 years in the judiciary as an advocate. The question is coming from a newly appointed judge. The question is that the person was appointed as a judge right after his graduation, with zero practical experience about working of the court. The person says that I'm always found to be under the scanner of all. And what would be your opinion in this regards? How can I cope up with this unwarranted mild stress?
It has been beautifully put, mild stress as such.
Yes, sir, yes.
I can gauge and feel what he must be undergoing if one is under a scanner for whatever it may be. I totally agree with that particular aspect. This issue in the context of that earlier the requirement was to spend 3 years at the bar.
Sure.
And then come for the judicial position as a judge. My own feeling and experience in this context is, I would say yes, that exposure at the bar necessary and gives you a kind of a feel and a feeling of the court. And you also get a feeling as to how you expect a judge to be conducting himself or herself if I were to become a judge in due course of time. It is absolutely understandable. And this exposure, this experience is required, is necessary. However, I hasten to add, my own feeling is most of those who join the bar to take the judicial service examination do not practice at the bar. They are preparing for the judicial service examinations. Invariably, exceptions apart. Because they feel that if they go to the profession, their whole time would be consumed at the bar and they would not be able to concentrate on their preparation for the. And therefore, in majority of the cases, this particular exposure is only a delay of 3 years as such, and not an actual exposure that would have helped them in this context. Having said that, now they come for foundation training for a year to the Judicial Academy. It's a 1 full year training which is given. Now, when they come to us, say they spend 6 weeks or 8 weeks with us, we send them for court attachment. They have a court attachment of 4 weeks. Come back to us. We have reflective sessions as to how and what they have learned. What is their experience? They come and share their experiences as such. And we tune our training further accordingly in the context in which the reflective sessions demonstrate to us. This process goes on for a year. We send them for police training, we send them for forensic science laboratory training, and many other aspects are covered in this particular context. The idea is to give them a good exposure. The idea is to train them in writing judgments, analyzing the evidence, and give them a practical exposure along with exposure in the courts. Now, this particular dilemma which has been expressed, that being at the threshold, they are under a scanner as such. I'm conscious the senior advocates, many a time, maybe overawing the younger judges, rather than, when they were young,
Yeah.
the judges used to encourage them.
Yes.
And therefore, the roles change in that particular process.
Yes.
I wish that that kind of a role is played by them. In fact, they have to do that. Equally, when a young judge goes to the court, should know the file, should have done the homework, should know the procedure which is required to be followed, should know the substantive law, not thoroughly, but basic as such, so that the lawyer doesn't get a feeling, oh, he is a novice.
Yeah.
And I can take him for a ride. And secondly, I would say, our young judicial officers must have senior judges as their mentors. And I have been saying that the judicial academies can be good mentors for the young judges as such. Mentoring is very important in your initial years of your judicial career. I think this particular aspect can be taken care, and we would look into it more effectively, though as yet this has not crystallized. But I have been toying with the idea that the younger judges must have mentors as senior judges or in the judicial academies. We could nurture them through their initial years as such. I wish them well. I wish them.
No, I think so. There's another suggestion from someone. The name has not been mentioned, and I think just adding to what you said, probably in a with different words. The suggestion is that, sir, IAS and IPS officers are also coming at quite a young age. So by getting out of a psychological pressure or so-called scanner, it is advisable to ask young judge to be learners in first few years and taking help from seniors by being humble rather than filling the chair. So
Absolutely,
exactly,
beautifully said.
it has to be both sides, sir. The
Beautifully said.
seniors have to help, but the juniors have to go up to them and say that, sir, I need to learn.
Absolutely.
Yes.
Humility is the basic hallmark of a judge. Young, middle-aged, or senior, humility must continue to be. And young judges, even during your life journey, we are all learners. I remember my teaching days to begin with. I would go to my teacher, senior, whatever would not be clear to me as such. There is absolutely no humiliation in that. This is what is actually expected of young minds.
So,
Very well said. I'm happy about it, and they must follow this learning process through the mentoring process, for that matter.
So I think we don't have any questions any further. I'll just give you one quick compliment that has been put over here. I think it's required because I think it's required for everyone. So the first compliment is that the lecture, How to Manage Stress, was wonderful, sir. We love your work. And then some of the participants called it a dose of strength. And it was a pleasure listening to you. And Oh, someone has said this session as a probiotic session. So, and then we have that, because you have cited such a great example, so it is highly motivational, and it also shows them that, it is not only them who's going through all these problems, it's also the stalwarts from this fraternity have also faced this, and learning from them with your examples has broadened their mind. So they're really highly motivational. Then there's a heartfelt regards from Priya Sood ma'am from Patiala. She's saying that thank you for a lucid, inspiring, and heartwarming session. It was a pleasure, privilege to have attended this session. A keen insight of the everyday situation that you face at the court, and reducing the stress and validating the responses. So she's saying thank you for that. Nice session from a lot of people. And then you are the master in showing a path to balance judicial and a personal life. Your lectures are required on regular intervals, sir. So, sir, this is a request for you. Your lectures are required on a regular basis, and they really thank you for that. And then there's one message from Nagraj sir from Telangana court, saying the message to judges is to manage the court and free from stress.
That's right.
Just don't really. I think I was reading Sadhguru. I was watching Sadhguru's. He said, you manage things which are precious to you. I don't understand why people say manage stress. Because you should not even manage stress. Why do you want to manage? You manage money, you manage your assets, you manage your family. You should not manage stress. You should let it go. It will go automatically. So then there is Jasmine ma'am from Jalandhar. She said, this occasion reminds me to share that there is a subtle difference between reaction and responding to a situation. I think she's referring to that the Darwin's.
Darwin's theory. That's right.
Because he didn't react. He just absorbed it because he understood.
Yes. That's right.
And then there is respect in public about judges to conduct. Okay, and then there's one suggestion from Amol sir, Amol Deshpande sir. I'm assuming he's from Maharashtra. He said, you have inspired all of us to be positive, to be upright, and to be smiling always. Thanks for your guidance and time. I think, sir, there's a lot of compliments. I think it will take me another, couple of more minutes, but I think we got this thing that it is actually was required. I think we all know about these things, but sometimes the reminder sessions and putting things in the right perspective by someone like you, I think it's needed. A reminder is needed.
Thank you so much.
Yeah.
Let me just conclude this session with a message to the judicial fraternity.
Yeah.
You are the future. You hold the strings. This is the strength. And you are the builders of the trust and confidence of the people in this great institution, the judiciary. I wish all of you well. God bless you. My blessings too. Thank you so much.
Thank you so much, Balram, sir. I think wonderful session, very wonderful. I think the compliments are evident. I think on behalf of, I'll just give a vote of thanks on behalf of the Academy and the SEC Online. I think I should not even say anything apart after this session is done, because I think I will not be able to do justice to even summarize it by summarizing it. I think we all know how session went. I think we all know how interesting this session and how relevant this session was. So first of all, on behalf of everyone, I would like to thank Balram sir, Dr. Balram sir, thank you so much for getting, doing such a great work and preparing these examples for this session. Like I said in yesterday's session as well, this session might be for 1 hour, but the preparatory work is sometimes for 1 day, sometimes for 1 year, sometimes it's the entire, experience of, like you said, that you've been working since so many decades. It might be of so many decades coming together and putting it in one place. So thank you so much, sir, for sitting down for us. You're not giving us only 1 hour, 1.5 hours. It's 2 hours almost. I'm sure you have done your homework beforehand for, for almost like two to 3 weeks. So thank you for so much for that, sir.
Mr. Gill, let me conclude by saying you don't have to thank me. In fact, by giving me this opportunity, you have provided me a forum to enjoy myself. It has been a joy to be with you all. Grateful for giving me this opportunity. I'm so delighted, full of joy, happiness. Thank you.
We can see that on your face, sir, right now. We can totally see it. But I think I would really like to thank all the judicial academies who joined us, all judicial officers who have joined us from across India, Maharashtra, Telangana. We got some message from Telangana as well. I personally know a lot of people, a lot of members have joined from MP State Judiciary, a lot of from Maharashtra State Judiciary, from Bihar also members have joined in. Then other countries, neighboring countries members have also joined in. I'm getting a lot of messages on my personal number as well, so I will be able to see the other compliments coming on my chat. But thank you everyone for joining us. Thank you so much for making this success. Thank you for putting in that effort of giving feedback, giving compliments, asking questions in the chat section. I think Balram sir and I, we are both so thankful to everyone. And I, Chetan Singh Gill, on behalf of the Academy, Chandigarh Judicial Academy and SEC Online, would like to end this session now. Would like to conclude the session with a thank you. And with this promise that we will come again next week with something new. And we would love to share. So we will keep doing that. Balram sir.
Thank you.
Thank you so much.
Thank you.
Take care. Have a good day.
Good day.
Yeah.